Hi, and welcome to Hull and Estates. I'm Paul Trudelle,
And I'm Endrita Isaj.
and you're listening to episode number 631 on this cold January 2022 day. How are you today?
I'm doing well, Paul. How about yourself?
I'm great, thanks. Trying to stay warm and get some stuff done around here.
Good call.
Yes, but before we get to other stuff, we thought we'd spend some time today talking about a recent case that came out of the Ontario Superior Court of Justice, and one that I've blogged on in the past couple of weeks. It's an interesting case. It deals with vesting of property and who has standing to bring the application to have a declaration for vesting, and under what circumstances the court will say that property has vested in beneficiaries under a will. So maybe we can talk a bit about the factual background of the case and what gave rise to the motion that was before the court.
Absolutely. So let's get into a brief background of the case. So in Smith, the applicant is the estate trustee and the sole beneficiary of her late mother's estate. The only principal asset in the estate was a house in Port Dover, which was subject to a mortgage. The applicant had taken no steps to administer the estate, and the property remained in the deceased's name. The respondent is the applicant's spouse, who she was separated from. Before they separated, the applicant and the respondent had signed a promissory note in favor of a third party, which they agreed to be held liable for a loan of approximately $651,000. According to the respondent, at the time of the hearing, the amount owing on the loan had amassed to over $1 million. The creditor had begun to threaten commencing legal proceedings to collect the loan. The wife had no assets in her name. As mentioned, she was the sole residuary beneficiary of the estate, with the principal asset being the Port Dover house. The respondent, in turn, brought a motion seeking order vesting ownership of the Port Dover property in the applicant and requiring her to register the requisite documents on title to give effect to that transfer. So the reason why the respondent took these steps to bring this motion was because before they separated, they had signed this loan agreement together, and the respondent did not want to be on the hook for the debt to the third party creditor. So brought the vesting order to permit the applicant's beneficial ownership of the property to become available to their joint creditor, which, as we'll discuss further, was unsuccessful.
Right. Yeah. So I guess the open and honest concession of the husband was that he was bringing this application to have the property vested in the wife so that he wouldn't be the only one on the hook. He wanted the wife to have some property or means of satisfying this debt, and he wanted the wife to be the owner of the property that previously belonged to the wife's mother, so that that asset would be available to pay the creditors. So that was actually acknowledged and referred to in the decision. The husband moved under Section 9 of the Estates Administration Act, which is the vesting provision that states that any property not disposed of or distributed amongst the persons beneficially entitled to within 3 years of the date of death vests beneficially in that person. And the husband's argument was simply that 3 years had passed from the time of death. The wife was the sole beneficiary under the wife's mother's will, and therefore beneficially entitled to the real property. It should vest in her. And that was the basis upon which the application, the motion in the context of the family law proceedings was brought. The court looked a little bit more closely at Section 9 and felt that the provision didn't apply. The court referred to a Court of Appeal decision, de Michel and de Michel, that addressed the issue of vesting and when that section will apply. And it found that it didn't apply. And perhaps we can get into the reasons why the vesting provision didn't apply in these circumstances.
Most definitely. So, like you mentioned in de Michel, which was relied on in this decision, the Court of Appeal held that Section 9 of the Estates Administration Act applies only to the context where it does not conflict with the provisions of a will and may not limit the scope of an estate trustee's power to sell property. So in de Michel, the Court of Appeal held that where a will gives the estate trustee a power to sell property as the estate trustee sees fit, Section 9 is not going to limit the scope of that power by requiring that the property vests after 3 years. The Court of Appeal confirmed that the intention of the deceased, as expressed in their will always be paramount. And applying de Michel to this case, the court examined the deceased's will and found that the will provided the estate trustee the power to sell the property as the estate trustee saw fit. So this led to a similar result as we saw in de Michel, which was that entitlement under the will does not amount to an interest in property.
Right. So I think it's important to, and what the court was very concerned about what the terms of the will were in this matter. And I think when the motion was first brought, the court didn't have the benefit of seeing the will and asked that the parties provide the will. After the will was provided, the court was able to determine that yes, the estate trustee did have the power to sell at any time under the will, and therefore the property didn't, the Section 9 didn't apply to vest the property with the wife.
Exactly. And as such, the court found that the respondent did not, meet the requirements, and therefore his motion to declare that the property vested with the applicant had failed.
Right. Just as an aside, the husband also attempted to rely on Section 9 of the Family Law Act. So the Family Law Act that allows the court to make vesting orders, and found that didn't apply either. The court found that I think it was Rule 9, provides that, Section 9 of the Family Law Act allows the court to make a vesting order in certain circumstances. The court found that was more of an enforcement provision rather than giving substantive rights to the parties. So if there was an order in favor of the husband for a certain amount, or in favor of the spouse or the wife, then the court can make a vesting order declaring the property vested in order to satisfy that judgment. But in this case, there simply was no judgment against it, in favor of either the husband or the wife with respect to the property, and therefore that section didn't apply as well to allow the husband to succeed on having his property vest with the wife.
Exactly.
Okay. Well, I think that the case is a good discussion of Section 9 of the Estates Administration Act and the provisions and when they will or won't apply. It was a novel approach or attempt by the husband to bring this motion to have a declaration that the property be vested with the wife. Usually those motions or applications are brought by the beneficial owners, the people who get the property under the will, and they want the property in their name. In this case, the wife didn't really want the property in her name at this time, so that it wouldn't be available to satisfy the judgment. It may be that she, will be liable for her share of the judgment down the road, but at this point, this property wouldn't be available to satisfy that judgment or the debt obligation.
Exactly.
Hey, well, thank you for discussing that with me, and we want to thank you, our listeners or watchers, for watching. If you have any comments, please visit our webpage and send us a comment on our blog page. And until next time, thank you for listening. I'm Paul Trudelle.
And I'm Endrita Isaj.
Thank you. Goodbye.
Thanks.